representing a client in the purchase or sale of a new construction home or real estate development requires a deep understanding of both the legal and practical responsibilities that govern such transactions. New home sales differ significantly from resales of existing homes because they involve builders, developers, construction contracts, and specific regulatory requirements under Arizona law. Licensees must act with due diligence, ensuring that all representations, timelines, and disclosures comply with both the Arizona Revised Statutes, ARS, and the Arizona Administrative Code, AAC, while maintaining fiduciary obligations to their clients. The foundation for understanding new home sales lies in ARS Section 32-2181 through Section 32-2183, which requires developers to obtain a public report from the Arizona Department of Real Estate ADRE before offering subdivided or unsubdivided lands or timeshares for sale. This report discloses critical information about the development, including title status, physical conditions, legal access, utilities, and other factors that materially affect the property's value. A licensee representing a buyer in a new home community must confirm that the builder or subdivider has received an ADRE-issued public report and that the buyer has been given a copy before signing the purchase contract. Failure to provide this disclosure can render the contract voidable. Under Arizona Revised Statutes, Section 322183. For example, if a salesperson assists a buyer in purchasing a new home in a subdivision outside Tucson where utilities have not yet been installed, the buyer must be informed of this fact in the public report. If the builder does not disclose that the utilities will not be available for 6 months, this omission could be deemed a material misrepresentation and a violation of both ARS Section 32-2153, prohibiting misrepresentation, and Commissioner's Rule R4-28-1101B, which requires honesty and full disclosure. A key distinction between resale and new home transactions is that most new homes are sold using builder-specific purchase contracts, which differ from the standard Arizona Association of Realtors residential resale real estate purchase contract. These builder contracts often favor the developer and may include provisions that limit liability, define completion timelines, specify upgrade costs, and require the buyer to use certain title or escrow companies. Licensees must not provide legal advice, but are obligated under R4-28-1101K to recommend that clients seek professional assistance, such as an attorney's review, before signing. Additionally, new home sales may involve lot reservations prior to final subdivision approval. Under ARS Section 32-2181.03, developers may accept refundable deposits for lot reservations before obtaining a public report, provided that specific statutory conditions are met, including holding funds in an escrow account and limiting promotional advertising. A licensee assisting a buyer in such circumstances must ensure that the reservation agreement clearly states that it does not constitute a binding purchase contract until the public report is issued, and that the buyer's deposit is fully refundable. Another unique component in representing buyers in new home sales is construction inspection and warranty awareness. Builders typically provide limited warranties covering workmanship, materials, and major structural components. Licensees should advise clients to obtain professional home inspections, even for new builds, to verify compliance with building codes and quality standards. Under R4-28-1101I, a licensee must exercise reasonable care in communicating material facts and may not assume that new automatically means defect-free. When representing the builder or developer, a licensee must ensure compliance with advertising and promotional regulations under ARS Section 32-2153 and R42 8502C, which prohibit misleading claims or unsubstantiated statements. For example, advertising luxury homes starting at $300,000 when no units are actually priced at that level would constitute deceptive advertising, potentially subjecting the licensee to disciplinary action. New home sales also often involve complex relationships between the builder's representative, the buyer's agent, and the designated broker. A licensee must clearly disclose representation status in writing to avoid implied dual agency. Under R4-2, 8-1101E and F. If the agent works for the builder, the buyer should be informed that the agent represents the seller's interest exclusively. Conversely, when representing the buyer, the agent must ensure all builder disclosures are delivered and verified, maintaining the client's best interests throughout the process. Case Law Insight. State Bar of Arizona v. Arizona. Land Title and Trust Cobrels, 1961. Continues to be relevant in discussions about licensees preparing contracts. It reaffirmed that under Article 26 of the Arizona Constitution, real estate brokers and salespersons may lawfully draft contracts incidental to their transactions. However, in the context of new construction, this authority must be exercised carefully, as builder contracts often contain complex legal terms that may extend beyond a licensee's authorized scope of practice. Review Summary. Representing clients in new home sales requires understanding ADRE's public report requirements, builder contracts, and the distinction between lot reservations and purchase agreements. Licensees must exercise due care in disclosing material facts, verifying property readiness, and advising clients to seek professional guidance when contract provisions or construction details exceed their expertise. They must also maintain compliance with advertising laws and ensure that agency relationships are disclosed transparently. In short, working in new home sales requires a blend of legal knowledge, ethical discipline, and client advocacy consistent with Arizona's real estate statutes and commissioner's rules. Discussion prompts. Why is the ADRE public report so critical in new home sales, and how does it protect the buyer? Answer. It ensures the buyer receives full disclosure of the property's legal and physical conditions before purchase, making the transaction transparent and enforceable. What should a licensee do if they believe a builder's contract contains unfair provisions for their client? Answer. The licensee should not offer legal interpretation, but should advise the client to seek review from an attorney before signing. Why must lot reservation deposits be handled differently from earnest money deposits? Answer. Because lot reservations occur before subdivision approval, the deposits must remain refundable and held in escrow under ARS. Section 32-2181.03. Closing remarks. Working in new construction is an exciting yet highly technical area of real estate that tests a licensee's professionalism and legal knowledge. By mastering the public report process, maintaining ethical advertising standards, and protecting clients from contractual pitfalls, agents elevate their practice to meet the highest standards of Arizona real estate. Every new home transaction is an opportunity to combine compliance with care, ensuring both the integrity of the industry and the satisfaction of the buyer or developer.